Today, let us, what we'll do, because now only 4 days,
Good morning, sir.
4 chapters, sorry, 4 classes or 4 or 5 classes left for your PT3 examination. So we'll revise the chapter which are taught to you, or the
Yes,
syllabus
sir.
for the examination.
Okay, sir.
Today,
Good morning, sir.
good morning. Today,
Good morning, sir.
let us discuss about judiciary. Okay.
Okay, sir.
Chapter judiciary. Judiciary is a part of or one of the branch of the government out of the 3 branches. The government have 3 organs, namely legislature, executive, and judiciary. So today let us study about Indian judicial system. The Indian judicial system, the picture which you are seeing, this is a pic of which court?
Supreme Court, sir.
Supreme Court.
Of India.
sir.
Supreme Court of India is considered as apex court in India. Means Supreme Court is highest court of appeal in the case of civil and criminal law in India. So Supreme Court, that's the reason it is considered as apex court in Indian judicial system. So let us understand what is the role of judicial system in India. This is including 3 major functions. One is dispute resolution, second is judicial review. Okay. Now, what is dispute resolution? If you remember, I told the Supreme Court of India having 3 jurisdictions. Can you recall? Can you remember? 3 jurisdictions of Supreme Court of India, which I explained to you.
Yes, sir.
Tell me.
Sir, dispute resolution,
Tell
judiciary
me
review,
the
and
jurisdiction which I explained to you. First one, write down.
Jurisdiction.
First one, original jurisdiction. Original jurisdiction. Second one is appellate jurisdiction. First one, original jurisdiction. Original jurisdiction.
According
Okay.
to Wikipedia,
Okay.
in common
So,
law legal systems, original jurisdiction of a court
spelling of jurisdiction. JURISDICTION. Original jurisdiction. According to the original jurisdiction,
second one what, sir?
according to the original jurisdiction, write down, the Supreme Court can hear, the Supreme Court can hear, the Supreme Court can hear cases, Supreme Court can hear cases, 3 type of cases. First one, central government versus citizen of India.
Yes, sir. And state government versus state government, sir.
Yeah, that is what central government versus uh, citizen of India, then state government versus state government. So please try to
And
remember
dispute between state
the
and
last
central
one.
government.
Yeah, difference between
State and central government. Dispute between
dispute between state and central
central government.
government. Okay, so all these come under original
Apex court. Supreme Court, sir.
Jurisdictions.
original
Jurisdiction.
jurisdiction of Supreme Court. So you should recall all these things which I explained to you in the class. Second jurisdiction, that is called
Appellant
appellate.
jurisdiction.
appellate jurisdiction. Appellate is nothing but the power of appeal. Okay. So appellate jurisdiction means power of appeal. Please write down A double P
Sir, you
E
are not audible.
A double P LLATE. Now is it audible? Is it audible? Hello? Hello? Shoban? Hello? Okay. Appellate jurisdiction. We have been connecting problem. Net hoitari. Can you hear me? Can you hear me? Can you hear me? Appellate jurisdiction. Appellate jurisdiction means jurisdiction is nothing but area of power. Can you hear me? Hello? Can you hear me? Sharanamayyappa. Can net होता है सर router 4 no internet connected. Can you hear me? Hello? Can you hear me? Hello? Hello? What we have problem with the you are having a problem in the network. Cadets? Can you hear me? क्या करते हो? ಅದೇ ಹೇಳಿದ್ ನಾನು ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿ ಮತ್ತೆ ಕನೆಕ್ಟ್ ಮಾಡಿದೆ ಇನ್ನೇನು ಹಿಂಗೆ ಆಗಿತ್ತು Vice Principal's Galaxy. Can you hear me?
Yes, sir.
Sir.
Yes, sir.
Okay, now you can hear. There is a problem with the internet in the school. Okay, leave it. So, second one is called as appellate jurisdiction. Second one is called. Can you repeat with me?
Yes, sir.
Yes, sir.
Appellate jurisdiction.
Appellate jurisdiction.
Appellate
Appellate
jurisdiction.
means power to appeal. So, Supreme Court can hear the cases appealed from the lower court. Which is the lower court?
High Court and
High Court and
High court and lower court, sir.
High Court. So, Supreme Court hear the cases from High Court. Let it be civil or criminal. So second jurisdiction I told you, appellate jurisdiction. The third one is called advisory powers. Please write down advisory powers. Advisory power. According to the advisory power, the Chief Justice of India, CJI, can advise the President and Prime Minister of India in case they are having some complications or required advice on the legal issues. So, according to the original jurisdiction of Supreme Court can here take up cases directly. One, central government versus citizen. Second, state versus state. Third one, what?
Dispute between state and central government.
Dispute between state and central government. That is called dispute resolution. Clear?
Yes, sir.
Yes, sir.
Second one, what is judicial review? Okay, I repeat, judicial review means the power of the Supreme Court, to review the laws passed by the legislature, the power of the Supreme Court to review the laws by the legislature, and if those laws against the constitution, such laws can be cancelled by judiciary. Clear or any doubt?
Clear, sir.
Okay.
Sir, can you give example of each central government versus state government dispute, sir?
Central government was versus state government. Kerala, Rajasthan, and central government have a problem with the sharing of GST tax. Okay.
Yes,
In the past,
sir.
there was a case like Kerala state of Kerala versus central government regarding the right to property. Keshavanand Bharati versus the state of Kerala. Many cases in the past. Okay. So citizen versus central government, state versus state, and between the state and center. Judicial review understood.
Yes, sir.
The power of
Dispute is on.
a judiciary to review. Review is nothing but to look into what the laws passed by the legislature.
And
If the law is
government
according to the
versus
constitution, then there is no problem. But if the law is against the terms and conditions of the constitution, such laws can be declared invalid. By whom? By whom? By the Supreme Court of India. This is called as what? Can you hear me?
Sir, can hear you now.
This is called as judicial review. Can you hear me? Okay. Some problem मत हो एक मिनट. Huh?
Yes, sir.
What happened? Meeting is locked. इधर उनको इधर what is my screen is not coming. There's some severe problem in the net, means website, WebEx. Can you hear? Are you able to see the presentation? Hello? Huh? Hmm. Hello? Can you hear me? Hello?
Yes, sir.
Sir.
There's some problem in your net connection.
Yes, sir.
Okay.
Yes, sir. Yes. Okay, sir. Okay, sir.
I'll do one thing. I'll record video and upload. Okay.
Okay, sir. Okay, sir.
Can you hear me? No.
Okay, sir.
Yes, sir.
Yes, sir. We can hear you.
But can you see
Yes, sir.
the slide?
No, sir.
No, sir. No, sir.
No,
We
that
can't see the slide.
sharing is a problem. I don't know what happened. Now can you see?
Internet issue, sir.
Now it's okay, na? Now you can see, na?
No, sir.
Huh? Now
No,
also
sir.
No,
sir.
slide.
No, sir. We can't see the screen. We can see the
Yes, sir.
No,
Yes,
sir.
sir.
It is visible, sir.
Yes, sir. Yes, sir.
Visible, I know.
Sir.
yaar. Okay, we'll continue. So the
Yes, sir.
power of a judiciary to review the laws passed by the legislature is called as judicial review. Okay. Next point, that is upholding fundamental rights. Upholding fundamental rights and enforcing the law. That means it is the duty of the Supreme Court to protect the fundamental rights which are entrusted on the citizens by by the Constitution. Okay. Then we also discuss about independence of judiciary. Now, what is the meaning of independence of judiciary? It is very clear that there are three organs of the government. Can you name them? Can you name them?
Judiciary,
Sir,
executive, and
legislature, executive.
Judiciary,
Judiciary.
legislature, executive.
Okay, legislature, executive, and judiciary. So it is very clear that out of the three organs of the government, the two organs, legislature and executive, they are interdependent. They are interdependent. Whereas the judiciary, the third organ of the government,
Independent.
it is independent. Very good. That means judiciary cannot be controlled neither by legislature
or
nor by
executive.
executive. That means who is going to become the Chief Justice of India, it is purely because of his educational qualification and service merit.
Yes, sir.
It is not a political post. At the same time, the Chief Justice of India cannot be removed from the post by the central government for a silly or a simple reason. He can be removed with a difficult process called impeachment. Impeachment should be passed by both the houses of the parliament, that is Lok Sabha.
Yes, sir. And Rajya Sabha.
So till now, in the history of India, no judge of Supreme Court is impeached. So you can understand the work of a judge, the post of judge of Supreme Court of India, it is very secured. So that is
Yes, sir.
that why it is important to become a independence of why judiciary should be independent.
So that they can take fair decisions and not
Very
be
good.
dominated by any
Very
other
good.
person.
So they can take a fair decision. There is no need that they have to favor the government or
Government.
they won't come under the influence of any minister or the government. So they can take decisions, fair decision purely on the basis of evidences.
Evidences.
Okay. Okay. So that is about independence of judiciary. Now, next point, the structure of judiciary in India. I explained you, Indian judicial system is arranged in a pyramidal structure. At the top, we have
Supreme Court,
apex court called Supreme Court of
Supreme
India.
Court.
Supreme Court of India is having 25 judges, and the senior most of is called as CJI, Chief Justice
Supreme
of
Court.
India. Who appoints Chief Justice of India?
India.
Who appoints?
District courts.
President, sir.
President appoints.
President.
Okay. President appoint the Chief Justice of India. So, appointing the Chief Justice, the power of appointment of Chief Justice is given to the President of India. Okay. Below the Supreme Court, most of the states in India are having their own
High courts.
high courts. High courts. Below the High Court, we have Tahsil courts and the district courts. So, organizational structure of the judicial system in India, usually district or Tahsil level courts are there. About district and Tahsil level court, we have high courts. High court is the highest court of appeal in the state, and at the top we have what? Supreme Court of
Supreme Court.
Supreme Court, sir.
India.
Apex
I am
court.
going little fast because of the interruption from the net. Okay, then we studied about Goyal's case. Okay, Sudha Goyal's.
Sudha Goyal.
Okay,
storyboard, sir.
storyboard. Then
We studied storyboard.
about two branches of legal system. Which are the two branches of legal system? Civil and criminal. Civil and criminal are the two branches of legal system. Okay, two branches of legal system, civil and criminal procedure code. This difference, it is we studied. What is this criminal law and civil law? Are you with me?
Yes. Yes, sir.
Yes, sir.
Okay. Civil and criminal law. 9:30. Okay, 9:30. We have time now. Can someone read the difference
sir.
between civil and criminal law?
Can I read,
Yes,
sir?
sir.
Ah,
Criminal law deals with conduct or acts that the law defines as offenses. For example, theft, harassing a woman to bring more dowry, murder. It usually begins with the lodging of an first information report (FIR) with the police who investigate the crime, after which a case is filed in the court. If found guilty, the accused can be sent to jail and also fined. Civil law deals with any harm or injury to rights of individuals. For example, disputes relating to sale of land, purchase of goods, rent matters, divorce cases. A petition has to be filed before the relevant court by the affected party only. In a rent matter, either the landlord or tenant can file a case. The court gives the specific relief asked for. For instance, in a case between a landlord and a tenant, the court can order the flat to be vacated and pending rent to be paid.
okay, thank you. So, what is the major difference between civil and criminal procedure code? In the civil procedure code, you have to file a case. FIR will not be filed in the civil case. No arrest will be done. Okay, and
Yes, sir.
it is dealt with the civil. Criminal case, it is entirely different. If the incident happened, then you have to report to the immediate nearest police station. Then police station will start their procedure with the FIR. After FIR, they arrest the suspect or accused. After that, they are supposed to prepare charge sheet. The person who is arrested should be produced to the court of law, and defense lawyer and accused, the public prosecutor, they argue, and the judge play the role of a umpire in the court, and after that, based on the evidences, the judgment will be given. In the criminal procedure code, arrest and the punishment will be done, but in the civil procedure code, the civil branch, it is not there. Clear?
Yes.
Sir, but
Yes,
if
sir.
in the civil law it's a
Yes,
crime
sir.
committed, still the person won't be arrested.
No, civil law, pardon?
Sir, if in the civil law a wrong thing is done, still the person won't be arrested.
If the civil law, what happened? I am not getting your point.
If the landlord is doing something wrong and it comes under the civil law,
No,
yet the landlord won't be arrested.
wrong means define the wrong, like beating, something like that.
Yes, sir, threatening.
Threatening also come under criminal procedure code. Beating is 100% criminal, because if beating or physical injury means, definitely he can go for MLC, that is medical legal case. He should immediately report to the nearest district hospital, and once he report to the district hospital, inside district hospital only, then police constable will be there. It will be done MLC, that is called medical legal case. So that is not a civil case. It will turn into
Criminal case.
criminal case.
Sir, why it takes a long time for a judge to take decision against the accused person, sir, who have done a crime? Sir, in Nirbhaya's case, it took 7 years for justice, sir, to their family.
What happens?
Sir,
No,
they can even
understand. I
they can
understand.
even take decision within 1 day only, sir. Why they took 7 years?
Correct. I'll explain you. What happens now? Whenever a civil case or a criminal case, let us take Nirbhaya's case only. It takes the police arrest the suspected person. He is only suspected or accused. He is not a convict. Okay. So after that, the police ask the judicially that we need so much time to investigate. Okay. So first it will be done by the police. So till that, the person who is accused will be in the judicial custody, because he will be under inquiry. Then police may take few months to search evidence and all those things. Once it is done, then the equal right is there to the person who is accused. No, he may also, his lawyer may also ask for a time, because he should search for evidences and arguments to save his client. No, so like this, the case is postponed by the concerned people. That is the one reason. Second reason, what happened? No, in a single day, one case completely is not dealt anywhere, because let it be Supreme Court or High Court, in a day they deal different cases which will be in the different stage. You are getting point?
Yes, sir.
Earlier there was a system called fast track judgment. There was a lot of discussion that the government was requested that to have
Yes,
fast track judgment, but fast track judgment also, that is
sir.
not successful in India. Now imagine if a person is called today by the court of law, he can say that he can, through his lawyer, he can say that I am not medically fit. Since I am not medically fit, I cannot travel and attend the court. Once the person cannot attend the court, then do you think that procedure will happen?
Not audible.
That procedure cannot happen.
Sir, can you repeat once again?
Take for example,
Your voice was not audible in
It
between, sir.
cannot.
okay,
We can't hear your
now I'm
voice, sir.
saying in the case of Nirbhaya's only, accused person try his level best to come out from the case. Clear?
Yes, sir.
Yes, sir.
So what happened now? Whenever he feels that there is a possibility that arguments are strongly going against him, he can take the help of his lawyer, and he can have a medical ground. He avoid attending the court. Possibility is there, no? Or
Yes, sir.
even his lawyer can ask that due to the lack of evidences and we need much time, so it will be done. Okay, because judicial procedure, what happened? No, in a single day, judicial procedure will not happen, because you may take 1 year, 2 year, but don't give a wrong judgment. That is what the Supreme Court clearly says. In the judicial system, justice may be delayed, but should not be denied. Clear?
Yes, sir.
Yes, sir.
Okay. So branches of law.
Sir,
Sir,
Supreme
sir,
Court
what
can
if
overturn any judgment given, sir?
Pardon?
If Supreme Court gives a judgment and afterwards can it take back, sir?
Supreme Court cannot take the judgment back. If the take for example regarding Shabarimala verdict case, Shabarimala verdict case में क्या हुआ? Supreme Court allowed the women to entry into the temple, but the verdict given by the Supreme Court later challenged by the few governments. So what happened? The Parliament of India passed a resolution to stop and requested the Supreme Court reconsider the judgment. That's why the case is still pending. The same case happened in the case of Jallikattu in Tamil Nadu. What is Jallikattu?
Sir, it is a type of game in which bullock
Auction game,
race,
sir.
sir.
वो bull fighting, bull race का. That,
Yes, sir.
if someone is very meticulous in reading newspapers on Shankranti time only, this Pongal time only, uh, Jallikattu festival is generally that is a kind of heroism which is done in Tamil Nadu. The Supreme Court banned Jallikattu, but immediately there was a huge protest march in Marina Beach in Chennai, and the Tamil Nadu they said that it is our custom and tradition. So later what happened? Because of pressure of the Tamil Nadu government, central government passed a ordinance against the verdict of Supreme Court. That's the reason why the practice is still going on. So
Yes, sir.
such things are common. Means it may not happen on the daily basis, but there are enough examples. Clear?
Yes, sir.
Yes, sir.
Yes, sir.
Okay. Now quickly we go through the question and answers. The first one, independence of judiciary. The independence of judiciary allows the court to play a central role in upholding the law and enforcing fundamental right. It ensures that there is no misuse of power by the legislature and the executive. Anyone can approach the court if they believe that their rights have been violated, and politicians or other socially powerful people cannot use their power to change any judgment. Question number 2, fundamental rights provided in the chapter. The right to constitutional remedies allows an Indian citizen to move to the court if he feels that any of his or her fundamental right has been violated by the state. How many fundamental rights are there? How many fundamental rights are there? Fundamental rights number 6, 7, 8, 9, 10, 11. कितना है? Can you hear me?
Yes, sir.
Number of fundamental rights
Yes,
कितना है?
sir.
हाँ?
11, sir.
Fundamental
sir.
6.
Seven
There are
fundamental
totally 7
rights.
fundamental.
Six fundamental rights, sir.
Boys, you are not updated. 6 fundamental rights are there.
One removed, sir.
What is the
Sir,
last?
6
What is
right
the
to
And
last?
one
property was
removed, sir.
removed.
Six fundamental.
What is
Sir,
the?
right to
Right
property.
to property.
Okay.
Right
Right
to
to
property
property, sir. Right to
was
property.
removed.
Which is the last fundamental right? That is the right to constitution.
Right to constitutional
Remedies.
remedies.
Right to constitutional
Okay.
remedies.
Ambedkar called right to constitution remedies as a heart and soul of Indian constitution. So Ambedkar called right to constitutional remedy as a heart and soul of Indian constitution. So what is right to constitutional remedies? It is very clearly explained in the term itself. Right to constitutional remedy is not a right, but it is a right to claim all other rights. In case all the 5 rights are denied, then you can take the help of right to constitutional remedies
And approach courts.
and approach court. Clear? So
Yes, sir.
right to constitutional remedies is a right which protects all other fundamental rights.
Sir, why it is needed, sir, when one right means if we are not getting one right, however we are going, why we need another right which protects all the rights?
That is the procedure of constitution. Take for example, you when you go for an outpass, okay, there are many person you have to contact. House master, hostel superintendent, duty master, over and above vice principal or adam officer. Clear?
Yes, sir.
This is a procedure. This is a procedure. Now imagine your house master, hostel superintendent, and duty master denied, but you have a one option. You can directly approach vice principal or adam officer. If okay, procedure is procedure. So in the second procedure, imagine if you come with the outpass sign of your vice principal or adam officer, naturally, other it is easy to get other signature, isn't it? One example I am giving you to understand why fundamental right to constitution remedies is a right, because in case there is a denial, then there should be strong reason to get back your right. That's the reason why right to constitution remedy. According to that only, there are writ of habeas corpus, writ of mandamus, writ of certiorari, writ of quo warranto, writ of prohibition. All these things are done according to under right to constitution remedies. This all I'll explain you once you're back to school. Okay. Writ is nothing but order of the court. Order of the court. Is okay. Okay then. Third. Judicial. Okay. What is PIL full form? What is PIL full form?
You are not audible.
Public interest. Public interest.
Sir, you are not audible.
Yeah, because problem with the net. I'm asking you what is PIL? What is PIL? Public
Public interest litigation.
Public interest litigation. Okay. Okay, cadets. We'll continue tomorrow.
Sir, I have a question.
There's severe disturbance in the net connection. Okay. Thank you.
Sir, can I ask some questions, sir?
Please ask.
Can some steps be taken to fasten the procedure of judgments?
That should be done by the central government by introducing fast track courts. Okay, take for example, now if a case is fought in Bijapur against the government of Karnataka, then like we have a branch in Gulbarga, that is called High Court branch, where more number of judges should be appointed by the government, so that more number of judges, more number of working days, working sessions, then the judgment can be speed will be increased. Otherwise, the procedure system of like what is there in USA. In USA, the federal court is the highest court of appeal. Means there is no Supreme Court in America. Whatever the cases discussed in the federal court, that is the final. But in Indian system, it is different, no? So only one court is there, that is Supreme Court. Most of the cases are filed or appealed to the Supreme Court. Naturally, the delay of justice has happened. Actually, this is one of the biggest problem of Indian democracy. The biggest problem. Okay. The procedure is like that.
Yes, sir.
Okay then. Take care. Thank you.
Thank you, sir.
Bye.